period for this, where it's case.
Yeah,
like,
we're
I'm
just
gonna
making
write
sure the video.
directs,
Perfect.
but
Yeah.
it's gonna need to
And we'll
be
bring it
spread
up
over
to you.
2 days
Okay,
to
cool.
have that
Sounds
be it all.
I'm not gonna have this.
Well, thanks for all your work on that tournament. And it's, Here. You guys can go ahead and come on up.
You may be seated. Good morning, council. This is the case of the estate of Peter Jones versus Dragon Studios. Could I please have counsel for the parties make their appearances, and for the record, if you could spell your last names for me.
Yes, Your Honor. Good morning. My name is Katie Volpert, spelled Volpert.
All right.
And today I'm joined at counsel's table by my co-counsel, Matthew Fleischer.
Spell, please.
Good morning. My last name is Fleischer, Fleischer.
All right, thank you very much. And for defendant Dragon Studios,
Good morning, Your Honor. My name is Sam Farnsworth. My last name is spelled Farnsworth.
one more time if you could please.
Of course. Farnsworth.
All right, just the way it sounds.
Exactly.
All right, thank you very much.
Good morning, Your Honor. My name is Ethan Donovan. That's Donovan.
All right, thank you very much, counsel. Before we do opening statements, are there any matters the court should consider?
Yes, Your Honor, we have a few brief housekeeping matters.
All right,
First, Your Honor, we'd just like to note that in this jurisdiction, witnesses are constructively sworn in and presumed to be sequestered, except for party representatives.
all right,
We don't have a party representative today.
all right. And
We do have a party representative, Your Honor. Mr. Cole Doig will be present at council table during trial.
all right, thank you.
Good morning, Your Honor.
Thank you, Mr. Farnsworth.
Your Honor, we'd also like to note that there are a number of exhibits in this case which are pre-admitted. That's exhibits 1 through 25, and we'll be referring to those exhibits through opening statements as well as throughout today's trial.
All right. That's fine with?
Yes, Your Honor, that's our understanding as well.
All right,
And Your Honor, just because this is our first time in your courtroom, we'd just like to ask your preferences about moving about the well. Would you like us to ask permission to approach witnesses, the bench?
You do not need to ask permission to enter the well, but if you approach the witness and are within an arm's length, I would appreciate it if you'd ask for permission, which will alert the witness as well as me that that's about to happen.
Yes, Your Honor. And finally, may we presume that when objections are sustained, the testimony's been stricken, or would you like us to move to strike?
You may assume that it's been stricken.
Yes, Your Honor. And with that, we're ready to proceed.
All right, and Mr. Farnsworth, anything for the defense?
Just one thing, Your Honor. Per the rules of this jurisdiction, we have to announce what verdict form we've elected to use for this case.
All right,
For this trial, we're going to be using verdict form C.
all right. That is denying liability and asserting comparative negligence,
Yes, Your Honor.
but not assumption of the risk.
Correct.
All right, anything else?
No, Your Honor. We're ready to go.
All right, I will start with the opening statements, but first I think I'm going to move the lectern so that it's not blocking my view of counsel table. Whenever you're ready.
Yes, Your Honor. 16 seconds of silence. It's June 21st, 2023, and movie star Peter Jones is filming a stunt for his new movie. He's plummeting to the ground. He's got a parachute on his back, a headphone in his ear. All he has has to do is wait for the signal to deploy his parachute. 5 seconds go by. Nothing. 10 seconds go by. It's quiet. 15 seconds go by, and all he can hear is the sound of the wind whistling by him as he hurtles to the ground. Desperate to save himself, he reaches back, he pulls on his parachute, but it's too late. He's going too fast. He's too close to the ground. He crashes. He dies on impact. Members of the jury, you're going to learn today that that signal was supposed to tell Mr. Jones when to deploy his parachute. That signal was supposed to help Mr. Jones reach the ground safely. You're going to learn that that signal was supposed to come from the defendant, Dragon Studios. But it never did. Instead, the last thing Mr. Jones heard was 16 seconds of silence. That's why Mr. Jones's family is suing the defendant for negligence. Now, in bringing that claim, we take on a burden of proof. We have to show by a preponderance of the evidence, which just means more likely than not, that 1, the defendant was negligent, 2, Peter Jones was harmed, and 3, it was the defendant's negligence that caused that harm. But members of the jury, you're going to learn that we're not the only people in this courtroom with a burden today. Because the defense has elected to take on an affirmative defense, something called comparative fault. And what that means is they have to show you that Peter Jones was negligent, that he caused his own death. But not just that, members of the jury, you're going to be asked to assign a percentage of fault at the end of this trial. You have to find that more likely than not, Mr. Jones was more negligent than the defendant, Dragon Studios. The defense, they're not going to be able to meet that burden today, but we're going to meet ours. And we'll do it by focusing on 3 points: the protocol, the precautions, and the priorities. So let's start with that first point, the protocol. Today we're going to call a talent agent to the stand. His name is Eli Gogion. He worked with Mr. Jones. And Mr. Gogion is going to tell you that the defendant actually changed the stunt last minute. You're going to hear that the defendant assured Mr. Jones that that stunt would be safe. Assured Mr. Jones that he would give the signal when the time came. Members of the jury, Mr. Gogion's going to tell you that he was in that control room with the defendant, and that signal, it never came. You're going to learn that as Mr. Jones plummeted to his death, the defendant was silent. That brings us to that second point, the precautions. Members of the jury, today you're going to see this photograph. This is a device called an altimeter. It's something that skydivers use to know how far away they are from the ground, how much time has passed since they jumped. You're going to learn that this is a device that can keep skydivers safe, even if that signal they're supposed to receive doesn't come through. The evidence will show that Mr. Jones, well, he wasn't wearing that device. He wasn't wearing that device because the defendant told him not to. That brings us to that third point, the priorities. Because the defendant, Mr. Doig, he's going to take the stand today. And when he does, you're going to learn that Mr. Doig ignored protocol, ignored precautions, all to get more exciting footage for his movie. You'll learn that time and time again, Mr. Doig was more worried about the aesthetic of his shot than the safety of his actor. Members of the jury, as you listen to today's trial, I want you to remember that this case comes down to trust. Actors trust their producers, their directors, their stunt coordinators. They trust their studios to keep them safe. The evidence will show today that Mr. Jones trusted the defendant. Trusted the defendant when they told him not to wear an altimeter. Trusted the defendant when they extended that stunt. trusted the defendant when they promised they would give him the signal. You're going to learn that that trust was rewarded with 16 seconds of silence. That's why at the end of this trial, I'm going to come before you once again and I'm going to ask that you find the defendant, Dragon Studios, liable for negligence. Thank you.
All right, thank you. Mr. Farnsworth, do you want to give your statement now or reserve?
Now, Your Honor.
All right. You may proceed when you're ready.
Thank you, sir. He took a risk for the perfect take. It's June 21st, 2023. Movie star Peter Jones is getting ready for a big stunt. He puts on his parachute, steps onto his motorcycle, and puts in his earpiece. He's nervous. He's about to drive off a mountain. But you're going to hear that he's done this stunt before. But this time's different. This is his last take, and he needs it to be perfect. He hits the throttle, rushes down the ramp, and flies 2,700 feet up in the air. He feels the wind buffeting his face as adrenaline shoots through his body, and he begins to fall. There are 9 seconds of silence, like plaintiff's counsel said. But then he hears the signal in his earpiece to deploy his parachute. But Mr. Jones, he's not ready to do that yet. He thinks that the longer he falls, the better the take will be. He thinks he has a few more seconds. He doesn't actually have. So when the second signal comes through, and he hears deploy, 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 this time he rips open his cord, but by then it's too late. Peter Jones dies. He takes a risk for the perfect take. Everyone in this courtroom agrees that what happened to Mr. Jones was a tragedy. It absolutely was. But today you're going to learn his death wasn't the fault of Mr. Doig or of Dragon Studios. You're going to hear they took steps to make sure Mr. Jones was trained and to make sure the set was safe. But you're going to learn that on the day of the crash, when Mr. Jones hears that signal, he doesn't deploy his parachute. And you're going to see that's why he died. Now in this case, the plaintiff has the first burden of proof. They have to prove by a preponderance of the evidence, or show you that it's more likely than not true, that Dragon Studios was negligent, or that they failed to exercise ordinary care, and that failure caused Mr. Jones' death. They're not going to be able to meet their burden, but even if they do, today we've raised an affirmative defense, something called comparative fault. And that means we're going to show you it's more likely than not that Mr. Jones failed to exercise ordinary care for himself. That when he heard the instruction to pull his parachute, he didn't do it. 3 facts will show you why we're going to prevail. First, they exercised care. Second, they sent the signal. And third, Peter Jones kept going. Let's start with fact number 1, that they exercised care. The evidence will show that Dragon Studios invested a lot into Mr. Jones' safety. They didn't have him just practice the jump once or components 10 times, no. They had him practice jumping off of motorcycles and skydiving over 1,000 times each. You're going to hear that they exercised care for his safety. And that brings us to fact number 2, that they sent the signal. We're going to call producer Cole Doig to the stand. He was in the control room the day Mr. Jones died, and he's going to tell you exactly what happened. That after 9 seconds of free fall, he sent that signal, that he told Mr. Jones to pull. Then he waited a few seconds and sent another signal, deploy. You're going to hear he sent the signal. But that brings us to fact 3. Mr. Jones kept going. Today you're going to hear that Mr. Jones was an action star. That the night before this signal, Mr. Doig and Mr. Jones had a conversation. And Mr. Jones was told that the longer he fell, the better the shot would be. That's true. But you're going to hear Mr. Jones was a daredevil. He loved his reputation for doing anything for the audience. So you're going to learn that when Mr. Doig sends that signal, Mr. Jones ignores it. Throughout this trial, I want you to focus on the risks that Dragon Studios protected Mr. Jones from, and the risks they couldn't control. Because today you're going to hear that a plan, it's only good if you follow it. But on the day he died, Mr. Jones didn't. That's why we'll ask you to find Dragon Studios not liable. Because he took a risk for the perfect take. Thank you. Thank you, sir.
Thank you, Mr. Farnsworth. Ms. Volpert, you have a witness for us?
Yes, Your Honor, and before we proceed, we'd just like to note that we do have one of those pre-admitted exhibits on a computer, so my co-counsel will be holding that up.
All right.
Your Honor, at this time, the plaintiff calls Mr. Eli Gogion to the stand.
All right.
May I proceed?
Whenever you're ready.
Good afternoon. Could you introduce yourself to the court?
Hi, my name is Eli Gogion.
What do you do for a living?
Well, I'm a talent manager.
How'd you get into all of that?
Growing up, I loved movies. When I was 5 or 6, I would just sit in front of the TV and watch Wizard of Oz over and over and over again. Eventually, I ended up becoming a lawyer, which was honestly a lot more boring. But at some point, I decided to sort of leave practice and use sort of my knowledge of the law to advise clients and help with things like that.
So do you know who someone named Peter Jones is?
I do. Peter was actually the first client I ever had. I worked with him for over a decade, and we ended up becoming really close friends.
What movies did you work on with him?
We worked on dozens of movies, but the ones you're probably most familiar with are the All Lost franchise. They're a pretty big action franchise, think Mission Impossible, Top Gun, stuff like that.
Sir, can you tell the members of the jury why you're in court today?
I was on set the day that Peter died. He was performing a stunt for one of those All Lost movies, and he didn't make it.
Okay, sir, let's take a step back and talk about how you planned that stunt. Were you involved at all in the planning process?
Yeah, as Peter's agent, I was sitting in on a lot of the meetings with the producers, with the stunt coordinators, and with sort of the whole crew.
What did you talk about in those meetings?
We talked about the best way to keep Peter safe while also making the stunts interesting and compelling.
Did you ever make any sort of plan to do that stunt?
Yes, the stunt coordinators, they came up with sort of a safety plan outlining the stunt and any of the precautions we were going to take to make sure that Peter was safe.
Sir, would you recognize a copy of that plan if I were to show it to you?
Yes, I would.
Let the record reflect, or my apologies, Your Honor, may I approach the witness with Exhibit 34?
Yes.
Your Honor, can I just see it before the witness sees it? Is that all right? Just to make sure that we're on the same page. Thank you.
Can you tell us what that is?
Yeah, this is that safety plan. It sort of outlines the stunt, the precautions, stuff like that.
Is it a fair and accurate copy?
Yeah, it looks like it.
Has it been changed or altered in any way?
No.
And can you tell us who signed that document at the bottom?
Yeah, Peter and I signed it, and then the stunt coordinator, Sky Stebbins, and then the film's lead producer, Cole Doig.
Plaintiff offers Exhibit 34 into evidence.
We have an objection, Your Honor,
All
to
right.
Rule 702. If you look at the last paragraph of this exhibit, you'll see that it contains an expert opinion about skydiving industry standards. There's no foundation on the record for who signed this document that has the requisite knowledge to make that kind of opinion.
Response, Your Honor?
Give me just 1 second.
Yes, Your Honor.
All right. Yes, your response.
Your Honor, Rule 701 and Rule 702, they apply to testimony that's being given in court because you're able to lay the foundation for those expert prongs. They don't apply to exhibits.
Right, but the hearsay rule does.
Yes, Your Honor, may I respond on hearsay grounds?
Sure.
Your Honor, this is an exemption under the party opponent rule, as one of the people who signed this document is the defendant.
That's true. Counsel?
Yes, Your Honor. The defendant doesn't have the requisite knowledge to adopt all of the statements within this document because there are statements that require expert foundation, like the fact that according to skydiving industry standards, a skydiver should have their parachute open and fully inflate at a certain point.
Response, Your Honor?
All right, very briefly.
When somebody signs a document, they adopt that statement as their own. When the defendant decided to do that, well, this became an exemption under the party opponent rule. If opposing counsel believes that that's not true, that that's the industry standard, well, he can ask his own defendant about that.
All right, let me tell you what my tentative ruling is, which is there's no question, I take it, that this plan was reviewed by the parties that signed it. And so, at least for that purpose, it's admissible, and I may, but we can revisit this at the conclusion of the trial, give a limiting instruction as to the extent to which that particular statement is anything other than what the parties were told as opposed to possessing some scientific basis itself. And so
Yes, Your Honor.
with that understanding, you may proceed.
Yes, Your
All
Honor.
right, thank you, counsel.
So, sir, according to this plan, how high was the jump supposed to be?
Well, we were going to jump off of a cliff. It was about 2,700 feet in the air.
How did you guys plan to help him land a 2,700-foot jump?
Well, once he got off the ramp, he was going to jump off the motorcycle almost immediately, and then he was wearing an earpiece in his ear. We were going to send him a signal from the control room telling him when to deploy his parachute.
Who was in charge of giving that signal?
It was Mr. Doig, the producer.
How long was Mr. Doig supposed to wait to give that signal, according to that plan in front of you?
The plan said that he would give the signal after he had been off the bike for 4 seconds.
Does it say why?
It says it's the industry standard.
Well then, sir, I want to talk about the actual filming of these stunts. Were you there on set that day?
I was.
How many takes did you do?
Well, we were filming over 2 days. We did 6 takes on the first day, and then we only did 1 take on the day that Mr. Jones died.
Okay, let's start with those first 6 takes that you just mentioned. How did those go?
They went perfectly. I watched from the control room. He went off the ramp, he deployed the parachute, and he was totally safe.
Sir, how long did Mr. Doig wait to give the signal in those first 6 takes?
4 seconds.
How do you know that?
Well, I was in the control room with him. We had a clock. I was watching it. I wanted to make sure that everything was going well, and when we followed this plan, everything did go well.
Sir, if you got 6 successful takes, why'd you do that 7th one?
Mr. Doig said he wanted to do another take.
Did he say why?
He said he wanted more footage, that that he wanted it to be longer, that it didn't look good enough.
How long did he say he wanted to wait?
He said he wanted to wait 9 seconds before deploying the parachute on that new take.
I want to talk about what actually happened when he filmed that 7th stunt. Were you there that day as well?
I was.
Sir, how were you able to see what was happening during the stunt?
There was this control room that I was in, that Mr. Doig was in, and they had all these monitors. It would sort of give us the footage as it was happening out in live time.
Let the record reflect, I'm now retrieving Exhibit 2, which is pre-admitted, showing opposing counsel. Your Honor, may I approach the jury to display this video?
Yes, you may.
And sir, I'm just going to face this away from you so you don't have to see this. I'm now playing the video for the members of the jury. So sir, can you tell us what was happening in the control room during that stunt?
Yeah, like I said, it was just me and Mr. Doig there that day. A lot of the crew had left. We were only planning to be there for the first day. We were watching the monitors, and at first it was like every other take. Peter, he went up the ramp, he jumped off the motorcycle, and he started falling. And I was a little nervous. I was watching the clock, and when it hit 9 seconds, Mr. Doig, he wasn't deploying the signal, and so I said, it's been 9 seconds, you need to do it, and he just put his hand up like this. And I kept asking him, I said, why aren't you deploying the signal? You need to send it, he's getting too close to the ground. But he just sat there.
Sir, did he even reach for the walkie-talkie?
No, it took him until 15, 16 seconds before he even grabbed the walkie-talkie to even try to send a signal.
At what point did Mr. Jones deploy his parachute?
It was 16 seconds after he got up the ramp. I don't know what made him do it. Mr. Doig, he didn't even send a signal.
So sir, in those 16 seconds, did the defendant say anything?
No.
Nothing further.
All right, thank you. Cross-examination, Mr. Farnsworth.
Yes, Your Honor. Before I begin, may I approach the witness to tender Exhibits 10, 12, 16, and 18? They're all pre-admitted.
Yes, you may. Here you go, sir.
May I proceed?
Yes, you may.
Good afternoon, sir.
Good afternoon.
I want to begin by talking about whether Dragon Studios exercised care.
Okay.
Sir, we can agree Dragon Studios invested a lot into Mr. Jones' safety, right?
Yeah, we spent a lot of time preparing for the stunt. We made that plan, like I said.
Part of this stunt involved a motorcycle jump, correct?
That's true.
Exhibit 10, sir. Dragon Studios constructed a motorcycle ramp just for this jump in California, right?
Right, that was one of the things we put into the plan. Peter trained on that ramp before we ever went to set.
Mr. Jones practiced jumping off that ramp multiple times in a harness, true?
Objection, Your Honor, to improper character evidence. May I be heard?
Yes, you may be heard.
Your Honor, opposing counsel is using evidence of a past act, the studio having Mr. Jones practice this jump repeatedly, in order to show that he acted in accordance with that when they changed the stunt to something totally different, well, he was still careful. Or the studio was still careful.
Response, Your Honor?
Sure.
We're not using this for any character evidence purpose. We're using this to show the steps the studio took to train Mr. Jones and to show that they exercised their care.
Brief response, Your Honor?
Very brief, yes.
They haven't laid the foundation that any of these jumps were done with the way the stunt was done on the day of, with that 9-second waiting period. Unless they lay that foundation, well, this isn't probative unless it's being used to show that character trait of carefulness.
I thought the question was, he practiced.
Yes, Your Honor, it was.
All right, overruled. You may proceed.
Yes, Your Honor. Sir, to be clear, Mr. Jones practiced jumping off that ramp multiple times, right?
That's right.
Over 1,000 times, true?
Yeah, that sounds about right. That was part of our agreement.
And he didn't just practice motorcycle jumps, did he?
No, we practiced the stunt in sort of two parts. We practiced the motorcycle jump off of that ramp, and then he also did a number of skydives so that he could sort of practice deploying the parachute and stuff like that.
That's exactly right, sir. He practiced skydiving over 1,000 times as well, true?
That's right.
And while Mr. Jones was practicing on this ramp, the studio was constructing another ramp in Norway, true?
Right, that's where we filmed the actual stunt.
Next to that ramp, they built a house for personnel, true?
Right.
And sir, inside that house was a control room, correct?
Yeah, that's right.
Now, sir, on direct examination, you said you liked the movie The Wizard of Oz, right?
I do, yes.
There's a phrase from that movie, the man behind the curtain, right?
There is?
The control room is kind of like that, isn't it?
Yeah.
Inside that control room, that's where you give Mr. Jones the signal to deploy his parachute, correct?
That's right.
And sir, on June 20th, Mr. Jones was able to successfully complete that stunt 6 times, correct?
Yes, when we were following the plan, that's right.
Every time Mr. Doig told him to deploy his parachute, he did so, correct?
That's right.
Then let's talk about what might have changed on June 21st. That night, you, Mr. Doig, and Mr. Jones had a conversation, correct?
That's right. Mr. Doig came up to us and he proposed that revision to the plan.
Mr. Doig said that a longer take would look better for the movie, right?
That's right. He wasn't satisfied with the footage we had.
By the end of the night, Mr. Jones had agreed, correct?
Right.
Sir, in your time working with Mr. Jones, he insisted on doing stunts that no other actor would do, correct?
Yeah, he was really into the action movies.
Objection, Your Honor, to character evidence?
Counsel, would you like to respond?
Yes, Your Honor. We're referencing a statement that this was Mr. Jones' belief, that he insisted on doing stunts no one else would do.
Response, Your Honor? The
Yes.
fact that he insisted on doing stunts that no one else would do is being used to prove a character trait of recklessness, to show that he acted in accordance with that trait. It's not the same stunts from this case.
Response, Your Honor.
All right.
Yes, we're not using this to prove that he insisted on doing stunts no one else would do on a prior act, so he would do it that way in the future. There's no dispute he did the stunt in this case. We're rather using this to prove that he insisted on doing stunts no one else would do, and that makes it more likely that he would push the boundaries of the stunt on June 21st.
Response briefly, Your Honor.
Okay.
The past act is him insisting that he do the stunts.
All right. Overruled. You may proceed.
Yes, Your Honor. Sir, you'd agree he insisted on doing stunts no one else would do, correct?
Yeah, I mean, he did a lot of stunts.
He told you he loved his do anything for the audience reputation, correct?
Yeah, we wanted people to like the movies.
Then let's talk about what he would do for the perfect take. Because on June 21st, you did one more take, correct?
That's right.
And as you said, Mr. Jones waited 16 seconds before deploying his parachute, true?
That's right.
Now, on direct examination, you claimed Mr. Doig never sent a signal. Is that right?
That's what happened, yeah.
Let's talk about why you might be saying that. Sir, Mr. Jones was a client of yours, correct?
Yeah, he was my first client.
Not just your first client, your biggest client, correct?
That's right.
Not just your biggest client, your friend, true?
Yeah, that's true.
Your close friend, correct?
He was.
You know his family members by name, correct?
Well, yeah.
You know his daughters,
Yeah, he talked about his daughters.
his parents,
Right.
and you know your close friend's family, they're the plaintiffs in this case, right?
Right. They're the ones bringing the suit.
Sir, you see that camera in the back of the courtroom?
Yes, I do.
You don't know if your close friend's family is watching your testimony now, do you?
Maybe I don't know whose camera that is.
But you do know your close friend's family, they're the ones who stand to gain if Mr. Doig is held liable, true?
I would assume so, yeah.
Thank you, sir. No further questions.
All right. Thank you. Any redirect?
No redirect, Your Honor. I just asked that the witness be able to step down.
All right.
And may I retrieve and publish exhibits 10, 12, 16, and 18 to the jury?
Yes, you may.
Your Honor, may we also publish Exhibit 34?
Yes.
And with that, the plaintiff rests, Your Honor.
All right, thank you very much. All right. Mr. Farnsworth, it's up to you now.
Yes, Your Honor. Defense calls Cole Doyle.
All right.
May I proceed?
When you're ready.
Good afternoon. Please introduce yourself to the members of the jury.
Sure. Hi, everyone. I'm Cole Doyle.
What do you do for a living, Mr. Doyle?
I'm a producer and a director for the studio that I founded. It's called Dragon Studios.
How'd you become a movie producer?
It goes back to my childhood. I didn't really have a lot of exposure to the arts where I was coming from, but I had a teacher who took me through a film class. That got me working on some pretty bad movies back then, but it inspired me to tell people stories, and I fell in love with it. So I turned that into a career, started my studio, and I've been doing that ever since.
Mr. Doyle, do you know who Peter Jones is?
I do, sir.
How do you know?
Mr. Jones was the star of the All Lost movie series that we were filming. He had been working with my studio since the first one, probably about 10 years.
Was he working for you when he died?
He was.
In what capacity?
He was filming another movie, that All Lost series, still in his same role, that action one.
Sir, were you planning on having Mr. Jones do stunts for that movie?
We were, sir. It was kind of the hallmark of the All Lost series to do big, daring stunts.
Then let's talk about the care you exercised before that stunt. Sir, what kind of safety precautions did you have in place?
We built a team together, devised a plan to make sure that the stunt was safe. We put him through required training to make sure he knew exactly what he was going to do. And then we put together some technology, just to make sure that we could track him while he was in the air and communicate with him.
Okay, let's break that down. You said you put together a team. Who was on it?
A whole bunch of qualified folks, more qualified than I. And then we had people on the ground who were helping Peter get suited in properly, as well as our stunt coordinator, who was responsible for making the plan safe, making sure all the details were safe.
And what kind of training did you put Mr. Jones through?
We asked him to do 1,000 different motocross jumps. Those are the ones where he's on a motorcycle jumping off of something. And then 1,000 different skydives to prepare.
What kind of technology did you use to make sure the stunt was safe?
We had him test this earpiece so we could communicate with him while he was in the air. We put trackers on him, his equipment, and had drones around him so we could track his altitude, see exactly where he was going to be while he was falling. And then we built a ramp so that he could actually practice the exact stunt that he was going to do on June 20th and eventually the 21st.
Okay, let's talk about how both of those days went. Sir, how'd the stunt go on June 20th?
It was amazing. We got the shots that we were looking for a little bit. He went off the ramp. He was able to parachute successfully to the ground. They were really good.
Then why do another take?
After review, we went back and looked at exactly what we got and found that we were a little bit short on the airtime that we wanted. So I talked to Peter about that.
Did Peter agree?
He did. I pitched the idea to get him to do a little bit more time in the air, and he said he could wait those longer 10 seconds.
Sir, how long did Mr. Jones agree to wait in the air before deploying his parachute?
So I talked to him about extending this original time from 4 seconds to 9 seconds when I would give the signal, and then he would eventually get that signal and deploy at 10 seconds.
Okay. And let's talk about June 21st. Sir, how'd the stunt start that day?
Started like the rest of them. He got suited in, harnessed, got on his bike, and started to proceed off the ramp.
Okay. Sir, I want to show you a video of the stunt that day, and I want you to walk us through exactly what you did while it was happening. Would that be okay?
Of course.
May I approach the witness, Your Honor?
You may.
I'm approaching with Exhibit 2, sword and evidence. All right, sir, can you see that okay?
I can, thank you.
Okay, we're gonna start at 7 seconds when Mr. Jones leaves the ramp. Sir, at this moment, where were you?
I was down in our control room. That was in a house that we had built on the property where we were filming. And it has screens in there where we can see Peter and make sure we are seeing his altitude.
And what were you planning on doing during this jump?
So in the control room, we have a clock, and that's how we're tracking how much time he's been in the air. And my job was to make sure that he got the signal. So I had a walkie-talkie, and I was going to message him by saying pull, to let him know when to pull his parachute.
Okay, then here's what I wanna do. I'm gonna have Mr. Donovan play this video, and I'd like you to say exactly when you signaled for Mr. Jones to deploy his parachute. Could you do that?
I can.
All right, go ahead, Mr. Donovan.
Stop. Right there. That's when I started to say pull, pull.
And sir, what's the timestamp there?
16 seconds.
What exactly did you tell Mr. Jones to do?
I started yelling, pull, pull. Didn't look like he was responding though, so I started yelling more. I said, deploy, deploy, deploy.
Sir, did Mr. Jones respond to that first signal when you told him to pull, pull?
No, I didn't know if something was wrong. I didn't know if he couldn't hear me, but he wasn't pulling the parachute.
Okay. And let's see what happens after that. Mr. Donovan, could you play the rest of the video? So those last few seconds are cut off. Do you remember what happened after Mr. Jones crashed?
I do, sir. In the control room, you can see everything. And even though Peter did pull his chute, it was too late. He was coming in too fast, and I saw him crash against the rocks. It was awful, sir.
What did you do after?
Me and Peter's agent, Mr. Gogi, and we took a helicopter down to the scene to check on Peter to see if he was okay, but he was gone by that point. So then me and my equipment team, we tested the earpiece that was in Peter's ear to see if it was working, to make sure everything was going okay.
Sir, how sure are you that on June 21st, you told Mr. Jones to deploy his parachute?
I'm 100% sure, sir. I was yelling into that walkie-talkie.
Thank you. No further questions, Your Honor.
All right. Thank you. Ms. Volpert.
Yes, Your Honor. May I proceed?
Yes, you may.
Good afternoon, sir.
Good afternoon.
As Peter Jones fell 2,700 feet to his death, you were silent, weren't you?
I was the opposite of silent. I was yelling.
So you're telling the members of this jury that you gave the signal when you were supposed to?
I gave it 5 different times, ma'am.
I want to talk about whether what you're telling us lines up with the testimony we've heard in court today, because you've been sitting in that chair all trial, haven't you?
Yes, I have.
So you heard Mr. Gogion testify, didn't you?
I did.
You heard Mr. Gogion say that at 9 seconds, well, you didn't give that signal.
I heard him say that. That's right.
You heard Mr. Gogion say that you didn't so much as reach for the walkie-talkie until 15
Objection, Your Honor.
seconds had
Under
passed.
Rule 403, needlessly cumulative. May be heard.
Yes.
Opposing counsel is just referencing a prior witness's testimony. That's proper for closing argument, but not for cross-examination.
Response, Your Honor?
Yes.
This witness has contradicted something that a witness just testified to under oath. We're allowed to present that testimony to them and give them a chance to address that.
All right. Anything further?
Yes, Your Honor. It's proper to confront witnesses, or, pardon me, to reference prior testimony during closing argument, not during cross-examination.
All right. I think it is proper cross-examination overruled.
Yes, Your Honor.
So, sir, I'm going to ask that question again. Mr. Gogion just testified that you didn't so much as reach for that walkie-talkie until 15 seconds had passed, right?
I heard him say that, that's right.
You heard him say that for 16 seconds. You were silent, right?
I heard him say that, yes.
He said that all under oath.
That's right, I believe he was under oath.
Sir, are you telling the members of this jury that Mr. Gogian just perjured himself in court?
Let me be clear, I don't think he would sit up here and intentionally lie, but I do think it's possible that he's mistaken.
All right, so you say he's mistaken, so let's assume for a second that you actually did give that signal at 9 seconds, all right?
Okay,
Well, sir, you heard Mr. Farnsworth crossing earlier on all the practice that you guys did, right?
that's right, we talked about those skydives and motocross jumps.
That's right, on direct examination you said you did 1,000 different motocross jumps.
We required Peter to do that, that's right.
You had Peter do 1,000 different skydives, right?
Exactly.
Sir, let's be very clear for the members of the jury, not one of those 1,000 motorcycle jumps or 1,000 skydives was done with a 9-second delay for that signal, right?
That's my understanding, that's right.
But you assured Peter, still, that 9-second waiting period would be safe, right?
In the conversation that we had,
Yes, sir, you assured him that it would be safe.
that's right, he asked me about that and I talked to our stunt coordinator and she said it was safe.
Is it your testimony today that the stunt coordinator greenlit that 9-second delay?
I spoke with her that same night, I asked her if this was safe, and that's what she told me.
All right, sir, I want to talk about what she actually said when you pitched that idea. Let the record reflect I'm now reading from a deposition, the deposition of the stunt coordinator, Miss Sky Stebbins. And I'll be reading...
Hang on just 1 second. Councilman?
Yes, Your Honor, we're gonna object hearsay to this deposition.
Response, Your Honor?
Yes.
Your Honor, it was already decided before court that this deposition, the person who was here for this deposition, has been deemed unavailable under
Right.
Rule 804A. Your Honor, since this is former testimony, this falls under Rule 804B. It's therefore an exception.
That's fair, Your Honor. Then we're gonna object under Rule 106, Rule of Completeness. There's portions of this exhibit that damage the credibility of the portion she's reading onto the record, and we'd ask that it be read in its entirety if opposing counsel read it, or not in its entirety, Your Honor, but we ask that we have the chance to read rebuttal portions onto the record as well.
All right, although I haven't yet heard what portions the council intends to read.
That's
because
fair, Your Honor.
I interrupted. So, Rule 106 certainly says what it says. So why don't we hear what council reads, and then if you think there is more that needs to be admitted under the rule of completeness, we can address that.
Yes, Your Honor.
So, sir, I'm going to read to you what the stunt coordinator said, starting at line 170. Question: how did you respond? Answer: I said, no way. That's cutting it too close, especially when I'm not there. So, sir, that's now a second person that's saying something different from you in court today. Am I getting that right?
I'm not quite sure what that person was responding to. I'm not sure if that's what you're asking.
Well, sir, you just heard me read a section that said that she did not greenlight that stunt. Isn't that right?
Objection, Your Honor. Misstating the deposition may be heard.
Yes, you may be heard.
Opposing counsel just read onto the record, how did you respond? I said, no way, that's cutting it too close, especially when I'm not there. There's no reference to the stunt she's referring to during her questioning now.
Response, Your Honor?
Probably unnecessary, but go ahead.
I mean, I can read the question and answer beforehand if you'd like.
Why don't
It's
you-
just unnecessarily long.
Why don't you do that?
Okay. Question: before you left, did you discuss the possibility of doing an additional take of the stunt? Answer: yes. On June 20th, before the group dinner, Cole Doig pulled me aside. Doig asked if we thought we could do one more take of the motorcycle stunt on June 21st, except this time, Doig would delay giving the signal until Peter had been in the air 9 seconds. Doig said, I used your numbers and worked it out. If I give the signal at 9 seconds, the parachute will be inflated by 13 seconds. Peter is still above 1,000 feet. That's still safe. Question: how did you respond? Answer: I said, no way. That's cutting it too close, especially when I'm not there. So, sir, I'll ask you one more time. This is now the second person that said something different than what you're telling us in court today. Did I get that right?
That's right.
No. This time, this is actually one of your employees, right?
No, that's not anymore. This is an independent contractor that we hired. The stunt coordinator has her own company.
Okay, so this time, that was one of your employees at the time, right?
That's right, she was working for us at the time.
Sir, are you telling us that Ms. Stebbins perjured herself too?
Objection, Your Honor, argumentative.
Response, Your Honor?
Anything other than its cross-examination?
No, Your Honor.
All right, overruled.
Yes, Your Honor.
So, sir, I'm going to ask that question again. Are you telling us that Ms. Stebbins perjured herself too?
Ma'am, I don't think anyone intentionally lied. What I'm saying is what she told me in the conversation that happened that night. That's all I can tell you.
Well then, sir, I want to talk about a third person who might have contradicted your testimony in court today. Because you remember being deposed before court, right?
I do.
Our attorneys asked you a few questions.
They did.
They asked you about what happened on June 21st.
That's right, we talked about the events.
They asked you about what happened after Mr. Jones died.
Yes, that's true.
They asked you about what you said in front of the whole cast and crew, right?
That's right.
And sir, when they asked you that, well, at first you said, I don't remember, right?
That's correct. Everything had just happened. I said that.
Well, sir, this was 8 months later, right?
Right.
And 8 months later, you said in that deposition, I don't remember.
That's right.
But then the attorneys, they asked you a follow-up question, didn't they?
They did.
They told you, well, we can just depose the crew members that were there, right?
That's what they said. That's right.
And sir, after they told you that they could just depose the crew members, well, then you remembered some pretty specific quotes that were said, didn't you?
Believe so.
Sir, after you were told that, well, you remembered Mr. Goguen saying, how could you do this, right?
That's right. He said that when we got down to the ground and checked on Peter.
Sir, after they said that, you remembered saying, I wanted a longer scene, right?
That's correct.
You remembered saying, I thought we had enough time.
I did.
You remembered Mr. Goguen asking you, why did you give him the signal at 9 seconds, right?
Objection, Your Honor, hearsay.
Response, Your Honor?
If I had a reporter, I'd have the question read back, but yes, go ahead.
Your Honor, it's a question. Questions have no truth value. This is not hearsay.
Response, Your Honor.
Yes.
This question does have truth value. Mr. Goguen says, why didn't you give the signal at 9 seconds? They're using it to prove that Mr. Goig didn't give the signal at 9 seconds.
Response, Your Honor?
Yes.
That's not what we're using it for, if I can proffer.
Yes.
We're using it to show the effect on the listener that after Mr. Goguen said that, why didn't you wait 9 seconds, that, well, he didn't deny it. He didn't say that he gave the signal. He said nothing.
All right, overruled. You may
Yes, Your Honor.
proceed.
So, sir, I'm going to ask that again. You remembered Mr. Goguen saying, why didn't you give the signal at 9 seconds, right?
I remember him saying that. That's right.
And sir, when he asked you that, well, you didn't deny it, did you?
No, ma'am. I didn't know what he was talking about.
Oh, sir, you didn't tell him, no, I gave the signal just like I was supposed to.
Ma'am, he was in the room with me. I didn't say that. No.
Sir, you were silent, weren't you?
I didn't answer the question. No, I didn't.
And sir, I want to talk about whether this could have been avoided. Let the record reflect that I'm retrieving Exhibit 6. Sir, you know what this is, don't you?
That's an altimeter. It's something that our divers can wear on their wrists to track the timing as well as their altitude when they're falling.
That's right, sir. You're aware that skydivers wear these to know how far they are off the ground, right?
That's right.
The skydivers wear these to know how many seconds pass, right?
That's right. It has a clock on there too.
Sir, you told Mr. Jones not to wear one, didn't you?
That's correct.
Sir, you told him not to wear a device that could tell him where he was in the air.
That's
Because
right.
you thought it
My
would
apologies.
ruin your shot. Isn't that right?
That's correct. I wanted him to not have that so he could have his angles gotten by the camera properly.
Nothing further. Your Honor, at this time we're going to be reading an excerpt from a second deposition.
All
If I
right.
could just have one moment.
Before you proceed, Mr. Farnsworth, do you still want something else from the deposition pursuant to?
Yes, Your Honor, we're going to be reading a few excerpts from the first deposition. And while I'm doing that, could I also get some clarity on which deposition opposing counsel is reading from now?
This is the deposition of Jess Lorenzo.
Okay. First, should I read onto the record per Rule 106?
I think it would be clear if we did it that way unless counsel objects.
No objection, Your Honor.
All right.
Okay. We're going to start by reading the question at 33 onwards. What was Peter like? The hardest working actor in the industry. He trained for movies like a professional athlete, unending dedication to his craft, total perfectionist. He could be demanding. But he was also extremely generous. After one movie we did involving a Lamborghini car chase, he gave me the Lamborghini. After another, he paid for my son's college tuition. We're also going to be reading from the last page of the deposition.
Well, before you proceed, counsel, do you have any qualms about whether that qualifies under Rule 106?
Yes, Your Honor, we don't believe that this qualifies.
Your Honor, we believe it absolutely does. It shows the witness's bias in their testimony. The fact is, this witness has credibility problems, and raising those credibility problems by reading portions of the deposition qualifies under 106. It ought to be considered in the interest of fairness.
Response, Your Honor?
Yes.
Well, we agree that it's possible that some of those bias statements might qualify. Most of those statements were about how Mr. Jones is a perfectionist, how he wanted the shot. Your Honor, they're using that to further their case. It has nothing to do with the testimony that was read onto the record earlier.
Response, Your Honor?
Yes.
We're reading that to give the full picture of the question and answer. We're not using it to show that specific portion of the testimony.
I think the portion about the gifts is admissible under 106. The perfectionist will be excluded. All right.
Yes, Your Honor. We're going to read another portion.
All right, go ahead.
Yes, Your Honor. Question on 203. Were you originally a party to this lawsuit? Answer, yes. At first, the Jones family sued my company in Dragon Studios, but then I settled with the Jones family. What were the terms of the settlement? The settlement agreement releases me and my company from any liability for Peter's death and says that I agree to testify for the plaintiff in this trial.
Counsel.
We have no objection, Your Honor.
All right, that'll be admitted as well.
Yes, Your Honor, but we do have an objection to this deposition being read onto the record under Rule 702.
All right.
Yes, Your Honor, we believe opposing counsel is going to be referencing testimony and arguing that it's expert testimony.
From whom? I'm sorry, I missed that.
Jess Lorenzo,
Who is?
somebody they hired to depose in this case.
Response to those grounds, Your Honor?
Oh, pardon me. Someone we hired to depose in this case.
All right. Yeah.
Your Honor, this is an expert that was retained by the defense.
Okay, all right.
That's true, Your Honor, but we believe that they don't qualify under 702. That's why we're not calling them.
All right. We can constructively have had a lengthy debate about the expert's qualifications, and I will allow the testimony to be read.
Yes, Your Honor.
I'll be reading from lines 69 and 70. Question, is it industry standard to use an altimeter? Answer, yes. And with that, we have nothing further, Your Honor.
All right, thank you very much.
No redirect examination, Your Honor.
All right, thank you very much. Anything further for the defense at this time?
No, Your Honor. We ask that the witness be excused and we rest our case in chief.
All right, you may be excused. Counsel, we are now set for closing arguments. Why don't you both take a moment or two to organize your thoughts, and then we'll hear from the plaintiff. All right, Ms. Volpert, whenever you're ready.
May I proceed?
Yes, you may.
As Peter Jones starts to fall, everything goes silent. 1, 2. As Coldoig sits in the control room, he's on the edge of his seat. 3, 4. Peter Jones's blood is pumping with adrenaline as he soars through the air. 5, 6. Every passing second is a better angle, a better shot, a better movie. 7, 8. That adrenaline turns to anticipation. Where is that signal? 9, 10. This movie could break box office records. This movie could make millions of dollars. 11, 12. Fear sets in. Where is the signal? Where is Cole? 13, 14. Members of the jury, old Doig, he's waiting just seconds. He thinks every passing second could make that movie even better than the last one. 15, 16, as he pulls on his parachute, he hits the ground. And everything goes silent. 16 seconds of silence. It's why we're bringing this claim of negligence against the defendant. Now, in bringing that claim, we took on a burden of proof. We have to show that more likely than not, it was the defendant's negligence that caused his death. But members of the jury, you heard that there's a second burden at play here today. Because if you find that Dragon Studios was in fact negligent, well, you're going to have to ask yourselves a second question. Was Mr. Jones negligent too? And if you think he was, well, it's their burden to show you that he was more negligent than Dragon Studios. Members of the jury, they didn't meet that burden today, but we met ours. And we did it by focusing on those 3 points we mentioned in opening statements. The protocol, the precautions, and the proof. So let's start with that first point, the protocol. Because members of the jury, everyone agrees about what the protocol was that day. The defendant had to give a signal. Now, when he took this stand today, he tried to tell you that he gave the signal. That he gave the signal and Peter Jones just decided to ignore it. But members of the jury, ask yourselves, does that make sense? I mean, you heard on cross-examination that just one day before, he was reluctant to wait 9 seconds, much less 16 seconds. Are we really supposed to believe that he inexplicably ignored that signal for the first time ever, doubled the waiting time, and practically guaranteed his own death? All for the 7th movie of a played-out movie franchise? That doesn't make any sense. And you learned why that doesn't make sense. It's because it's not true. Because when Mr. Gogion took the stand, he told you that that signal didn't come at 9 seconds. No, it didn't come at all. But members of the jury, even if that signal wasn't given, well, there was another way for Mr. Jones to survive that stunt. You saw this photograph in court today. This is called an altimeter. Something that skydivers are supposed to wear when they jump. It tells them how far they are from the ground. It tells them how many seconds have passed. It helps them get to the ground safely. Members of the jury, you heard from the defense's own expert that it's the industry standard to wear these altimeters. You heard that Peter Jones wasn't wearing one. And it's not because he didn't need to. It's not because he didn't want to. It's because the defendant told him not to. Why? Because he said it would ruin the shot. And members of the jury, that brings us straight to that third point, the priorities. Because what you learned in court today is that the defendant has one priority and one priority only, and it's not finding justice for Peter Jones. No, it's saving his own skin. Why else would he lie to you over and over and over again in court today? Members of the jury, first, he tried to tell you that after Mr. Jones died, well, when he went down to the scene, he doesn't remember what he said. But then you learned that when an attorney told him that they could just depose all of the eyewitnesses that were there, well, suddenly he recovered from his short-term amnesia. Suddenly he remembered some pretty specific quotes about that conversation, the whole conversation, in fact. And what did you learn? Well, you learned that his first thought after Mr. Jones died, well, wasn't to deny that he didn't give that signal. It wasn't to defend himself. No, it was that he wanted a longer shot. Brings us to that second line, members of the jury. He told you that that stunt was greenlit by the coordinator. But then I read that deposition onto the record, and you heard that that wasn't true. You heard that when the stunt coordinator was asked about that stunt, she didn't say it was safe. No, she said, no way. She said, don't do that stunt, especially without me there. And that brings us to the worst lie of all. Because when he took this stand, He told you that he gave the signal like he was supposed to. But members of the jury, there was somebody else in that room. Mr. Gogion took the stand today and he told you under oath that that signal never came. He told you that Mr. Doig didn't so much as reach for the radio until 15 seconds had passed. Members of the jury, when it was time to give that signal, he didn't give it. Instead, there were 16 seconds of silence. Find the defendant liable.
Mr. Farnsworth?
Yes, Your Honor. May I have a moment to set up? Yes. Excuse me. May I use the picture of the box? May I proceed?
Yes.
I wish Peter Jones was still here. I understand being upset that he died. I understand that it's a tragedy. Nobody in this courtroom is going to deny that. And I'm not even going to ask you to put your sympathy on the back burner because that would be impossible. But I am going to ask you to look at the facts of this case and see what they actually tell you. Now, the law that I told you about in opening statement boils down to a few simple questions. You're going to have these questions when you go back to deliberate. I want to take the rest of my time to explain how the law here applies to the facts that you heard. Because he took a risk for the perfect thing. Let's start with question 1. Did the plaintiff prove the defendant's negligence was a cause of Peter Jones' death? Now, that just means did Dragon Studios exercise ordinary care? And if they didn't, did that lack cause Mr. Jones to die? We showed you today they didn't just take ordinary care, they took extraordinary care. They had a control room monitoring the stunt. They had ramps built with a house nearby for safety personnel. They had ramps constructed in California to practice motorcycle jumps not just once, twice, 100 times, over 1,000 times. 1,000 motorcycle jumps and 1,000 skydives for practice, that's more than their duty. So when you go back to deliberate, you can answer no for question 1. But that brings us to question 2. Did the defendant prove that Peter Jones' negligence was a cause of his death? And that's really the heart of this case. Because this case, all it boils down to is whether or not that signal was sent. Plaintiff, they say that it wasn't, we say that it was. I'm going to give you 3 good reasons why you know it was sent. Reason 1, the plaintiff's witness had a reason to lie. You heard today that they were close family friends with Mr. Jones and knows their family. The family that stands to gain if Dragon Studios is held liable. Do you really think he would admit if his close friend ignored an instruction from someone inside that control room? No. He had a reason to say that the signal wasn't sent. The second reason you know that signal wasn't sent is because it's consistent with the video evidence. I want you to remember exactly what Mr. Doig said on direct examination. He said he sent the signal at the timestamp of 16 in the video. And the words he used exactly were pull, pull. And he said he waited a few seconds and said deploy, deploy, deploy. That's 5 words with a pause in between. So what I'm gonna have Mr. Donovan do is play that video, and I'm gonna voice over the commands that Mr. Doig gave. Let's see if they line up. Could you go ahead, Mr. Donovan? Pull, pull, deploy, deploy, deploy. That's the timing that makes sense. What Mr. Doig told you exactly lines up with the footage that was caught on camera. He ignores the first command, waits a few seconds because he thinks he can get away with it, and then on the second time pulls the parachute. The timings match up perfectly. But the best reason you all have to know that the signal was actually sent, it's not anything anyone said. It's what Mr. Doig did right after the crash. You heard he helicopters down. He checks on Mr. Jones, and then the first thing he does is check if the earpiece is working. Why would he do that if he didn't try to say anything through the earpiece? That only makes sense if he tried to send the signal and wanted to see if something else got in the way. I mean, think about it using your common sense. When you check if your headphone's working, you don't do that when no sound's coming through your phone. You do it when sound's supposed to be coming through your phone, but it's not. Mr. Doig expected sound to come through because he was the one making the sound. That's how you know he sent the signal. And that brings us to fact 3, that Peter Jones kept going. You heard today he had a reputation for doing death-defying stunts. Now, opposing counsel says, Mr. Jones, he should have worn this altimeter. But folks, if he was willing to ignore the signal he heard in the ear for a few more seconds of tape, why would he listen to the altimeter on his wrist? He made a choice that day to wait a few more seconds before deploying his parachutes. When Mr. Doig gave that signal, he chose not to listen. And that's why I'm going to ask you all to do something difficult. I'm going to ask you to write in yes for question 2, and write in a number over 50% for the defendant's responsibility. Because if he had pulled the parachute when he was first told to, that day would have ended differently. Separate the tragedy from the liability, and see that he took a risk for the perfect take. Find Dragon Studios not liable. Thank you.
All right, thank you, Mr. Farnsworth. Anything further, Ms. Volpert?
Very briefly, Your Honor. Could I get a time check before we?
You've got 39 seconds.
May I proceed?
Yes.
Mr. Farnsworth just got up here and told you that Mr. Jones took a risk for the perfect take. But members of the jury, I'll tell you what's worse than a short shot and a tame movie. A shot that you can't even show because it's so gruesome. And a movie that you can't even film because the star is dead. Mr. Jones had no reason to ignore that signal. He had never done it before, and he didn't do it on June 21st. There was no signal. Just 16 seconds of silence. Find Dragon Studios liable. Thank you.
All right, thank you, counsel. I have instructed the jury. They will deliberate and cast ballots.